So good morning, good afternoon, good evening, everyone. Welcome to CILS and Arbinsol's post-pandemic series. And this time we are back again, even bigger, even better, the big third-party funding debate 2.0. Now, before we begin with the event and the debate, I wish to invite our co-organizers for today, ArbitralWomen. And ArbitralWomen's president, Dana MacGrath, is here with us to share with us what ArbitralWomen is about, their purpose, and the kind of work they're doing.
Hello, I'm Dana MacGrath, president of ArbitralWomen and a proud supporter of today's program. As many of you know, ArbitralWomen is an international organization that is dedicated to promoting women and diversity in dispute resolution, with a rich history from our more than 25 years of work in this area. Our members span the globe from at least 40 countries. Some of our activities include publishing content that features leading women in dispute resolution on our website, in our newsletters, and on social media. Hosting and supporting events that reflect our mission to promote women and diversity. Supporting students by funding teams competing in MOOC competitions who are composed primarily of women and otherwise would not be able to compete without financial support. We also welcome all students to any of the many events that ArbitralWomen organizes. Promoting our members' professional achievements on our website is another way that we support our members, and we do so also in our news alerts and on social media. We also report on diversity initiatives in the workplace and beyond, and educate the international community about unconscious bias and ways to overcome it through our bespoke training program called the ArbitralWomen Diversity Toolkit. We also support the professional development of our members through our membership program and our new parental membership program. We encourage you to visit our website, arbitralwomen.org, to learn more about ArbitralWomen's programs, activities, and individual and corporate membership options. Membership is open to all women involved in any aspect of dispute resolution. Additionally, even non-members may sign up to receive our event alert emails, our periodic newsletters, and access the news page on our website that covers news both about diversity initiatives and substantive developments in dispute resolution that intersect with our mission to promote women and diversity. While we normally organize and support in-person events, during the COVID pandemic, ArbitralWomen has organized several virtual events, and we have co-organized and supported many virtual events on both issues relating to diversity and substantive issues of dispute resolution. ArbitralWomen is honored to support today's program, the Big Debate 2.0, third-party funding and international arbitration. It is fantastic to have 4 ArbitralWomen speakers on this program. Without further ado, I look forward to today's debate.
Thank you very much, Dana. So as not to eat too much into the time that we have for this debate, I'm going to try to be very brief and let us get things on the road just by introducing our 2 moderators briefly, so they can in turn introduce the sterling panel that we have here today. First, I'd like to introduce Mr. Ishan Madan, who is the founder of Arbinsol. He's an Indian advocate of nearly a decade experience in complex commercial disputes and certified for admission to the New York State Bar. Having completed the University of Miami Masters in International Dispute Resolution in 2019, Ishan is extensively focused on international arbitration. And earlier this year, in anticipation of the business calamities of COVID-19, Ishan founded Arbinsol. And I think he's never looked back. I think it's been a really great start for him. Our second moderator is Dr. Kabir Dugal, who is a senior international arbitration advisor at Arnold Porter in New York. Looking at his bio, I saw that he serves both as counsel and arbitrator, and I thought, oh my God, he's double hats. What a terrible person. But I'm sure he doesn't do that in the same case. Kabir's list of achievements is much too long to do justice to now. It's just way too long, Kabir. I think it makes people uncomfortable. And so I'm going to stop there. That's enough clowning from me. And Ishan, Kabir, if you would introduce our panelists, we can get started.
Thank you. Thank you so much, Chris. And thank you everyone for joining in, especially for the US. It's still 9 a.m. in the morning. And thanks a lot for those who actually are making the effort to join this very important and very powerful and exciting debate that we are going to have today. So first off, thank you, Chris, for the introduction. ArbitralWomen, as most of you would already be aware, is an organization promoting research, dialogue, and thought leadership on international arbitration and insolvency and their interplay. And this debate today is also part of the same series that we are continuing, which specifically talks about one very important thing, which is a hot topic, third-party funding. Now, third-party funding has over the years become an extremely important and critical tool, assisting access to justice for those who can't afford it or prefer to use their limited liquidity and capital to advance business objectives. Cersei Lannister from Game of Thrones said, "Power is power." Uncle Ben from Spider-Man said and told Peter Parker that with great power comes great responsibility. But there have been calls for setting up a regulatory framework in respect of third-party funders within the field of international arbitration. Today, we'll cover a lot of ground, perhaps discussing third-party funding. But before that, let me introduce our stellar panelists. Of course, you've all heard that we have an all-arbitral women panel today, and we are very grateful and excited for that. Dana MacGrath, as you've already heard her, is an investment manager and legal counsel at Omni Bridgeway, responsible for leading the company's investments in international arbitration matters. Rekha is the executive director of the New York International Arbitration Center, a nonprofit organization that promotes and enhances the conduct of international arbitration in New York. Thanks to both Dana and Rekha for supporting our event through their organizations too. We also have Dr. Crina Baltag. She's a senior lecturer in international arbitration at Stockholm University, a qualified attorney with extensive practice in international arbitration and investment arbitration. She's also the editor at Kluwer Arbitration blog, and she's also an international arbitrator. And last but not least, anyone who is aware of international arbitration already knows Arbitrator Intelligence founder and CEO, Professor Catherine Rogers. What maybe in our audience would not know is that Professor Rogers was also the co-chair of the task force on third-party funding, which was conducted by Kumul and Ika together. So we are very excited to have these people who know so much about third-party funding inside out, are all arbitral women, and are going to talk about the topics. I'll request Kabir to please introduce the debate.
Fantastic. Thank you so much, Ishan. And I'm delighted to be here. I have my pumpkin spice latte in front of me. You can judge me all you want, but that's giving me the energy to begin this morning. I think most of my energy actually does come from this absolutely fantastic panel that we have in front of us. 4 women, as we often say, right? The future of arbitration is women. But for me, these are also people I greatly respect and admire. And so I'd like to express my gratitude and my thanks to each of them for agreeing to come in. For most of them, it is pretty early. For Professor Crina Baltag, she's taking time off her teaching to join us, so we really, really appreciate it. Welcome everybody to our second debate on third-party funding. And the motion that we have today in front of us is, this House believes that international commercial arbitration would be safer without third-party funding. I'm going to repeat the motion once more. This House believes that international commercial arbitration would be safer without third-party funding. As I just mentioned, this is the second in our debate series. We had a debate a couple of weeks ago where we had a similar motion looking at investor-state arbitration and what implications third-party presented when it came to investment arbitration. In course of that discussion, some of our speakers had touched upon ideas relating to international commercial arbitration, and that led us to think about having this debate. For those who have missed the prior debate, you can find it on the Arbinsol website. You can find it on YouTube. So definitely check it out. Now, third-party funding presents a very, very interesting dichotomy. I'm not going to get into any details. Our fabulous panel will do that. But, at least in common law countries, rules on champerty and maintenance generally used to prohibit that. But in about the last 2 decades or so, we've seen a very rapid increase in countries allowing third-party funding. And that is beginning, at least, to present new ideas or ideas that were not foreseen. And our absolutely amazing panel today is going to tease out some of these issues. Now, let me just explain the teams with one initial caveat. We're all friends here, and the idea here is to have a rich, enlightening discussion. And we welcome you, our participants, to put in your questions, comments, observations using the Q&A feature. So we welcome you to do that. But we have divided our 4 speakers into a team arguing for the motion and against the motion. And the team arguing for the motion, each of them will wave. This is something I'm making up as we go along. It's Professor Catherine Rogers and Rekha Rangachari. The team arguing against the motion, it's Dana MacGrath and Professor Crina Baltag. Let me just tell you a little bit about how we're going to go about this debate. Each of our speakers is going to make opening arguments for around 5 minutes or so, right? So each of them will make opening statements. This takes us to around 20 minutes. Now we are going to be serious about time. And how are we going to be serious about time? Ishan is going to ding something somehow. And if the ding doesn't work, Ishan is going to start dancing. So that's going to be a cue for our speakers, sort of, I think, 30 seconds when they remain, you will hear Ishan giving you the ding, giving you a signal that your time is approaching, right? That's what we're going to do. Then we're going to facilitate, Ishan and I will facilitate a question and answer between our panel. We'll have a little bit of a back and forth for around 30 minutes, depending on time. And then our speakers will make closing arguments for 2 to 3 minutes. We're again going to follow the same ding concept. Now, I will pass the floor to our speakers with one very, very important caveat. Okay, and I wanted to keep this later so everyone can join in. We have 4 very prominent speakers and speakers who are involved in a plethora of activities. We have professors, we have people from funding organization, from institutions. They're all key players, but that also, as Ishan said, great responsibility comes with these powerful positions. So we just want to emphasize that debates of this nature are being undertaken to facilitate the arbitration process. And to that extent, our speakers are speaking purely in their individual capacity on topics that we have told them to speak about, right? So please do not hold this against them. Please do not be those annoying people who will then in a hearing 20 years later take this video and put it, don't be that person. Okay, with this Chatham House rules, or as we say in the United States, the Vegas rule, what happens in Arbinsol debates remains in the Arbinsol debates. We're going to start off with Rekha opening in support of the motion for 5 minutes. Rekha, the floor is yours.
Hi, everyone. Thanks so much. Good morning from New York. And sincere thanks to Ishan, to Arbinsol, to Chris and CILS, and to Kabir. Ladies and gentlemen, as the motion has been introduced, we're here today for a debate. It's about specifically international commercial arbitration. As Kabir has already said, we've covered ISDS in a past debate, and litigation funding is also off the table. But as our esteemed speakers are all very well versed in ISDS, and if you'll indulge us, they may veer into that in some regard. Now, we're talking about safety in third-party funding TPF. Safety, as you all know, a condition of being protected from or unlikely to cause danger, risk, or injury. It implies assurances and protections. However, when we talk about TPF globally, there is an air of uncertainty. Lack of consensus permeates even when we're talking about sophisticated commercial parties. It's private commercial arbitration with party-appointed arbitrators, and it gives rise to various ethical and procedural issues. So let's start with a series of uncertainties. First, how do you define TPF? It manifests in many forms. For example, there is the common reality of a client who goes to an institutional funder, an agreement of costs, the funder covers the party's legal costs and expenses of the claim, they enter into an assignment to the funder, and some percentage or a substantial percentage of any proceeds of the case go to the funder. But funding can also be a solution obtained to include commercial contracts, insurance contracts, attorney financing, and contingency fees, conditional fees. We'll get into that a little bit later. And portfolio funding, legal expenses, loans, assignment of claims, and onwards, all within the realm of third-party funding. So we have a lot of curiosities therein. Next, as to another uncertainty, the lack of consensus as to regulation. Third-party funding is virtually unregulated. Neither funded party nor third-party funder are subject to mandatory global disclosure obligations regarding the funding agreement. And I'm talking here as to disclosures of conflict, actual, potential, or perceived. International regulations are currently silent in connection with TPF, mainly because funders are not included in any of the roles outlined under arbitration rules and international conventions. And certainly safety does not lie in unregulated markets. It's an unknown labyrinth. The rules of arbitration are arguably a reflection of the stakeholders. And within the sphere, they don't currently demonstrate a clear strategy of oversight as it pertains to TPF. So let's briefly take stock of global jurisdictions and what's at play. As Kamir mentioned earlier, this idea of maintenance and champerty has been abolished for some time. And so we're seeing a growth and a rise of third-party funding. In the UK, for example, TPF is self-regulating. There are voluntary associations that funders can join, like the Association of Litigation Funders, which sets out minimum standards for TPF. Much of it is unregulated. In Asia, specifically in Hong Kong and Singapore, as I know there's been a lot of discussion of on the interwebs, again, maintenance and champerty abolished. They're carving out regulations and oversight, and they are spaces to watch. TPF is becoming not only legal there, but they're implementing codes of conduct and practice with advisory boards and compliance. The burden ends up being on the lawyers for systematic disclosure, but in Singapore elevates disclosure by the parties, and we look to SIAC as an example, giving the tribunals power to order disclosure of TPF and details of the TPF interests involved. And then we look to places like Australia and New Zealand, requiring disclosure at the outset of the dispute. In the US, in contrast, although it's not privileged information, TPF will be disclosed if asked, but not the funding agreement. And so ultimately we have this reality of inconsistent standards on disclosure that can be hazardous for international arbitration until we get to consistency. We're talking about safety here. Inconsistent standards lead to inconsistent regulation. And so we also have to look to conflicts. Cognizant of the time, I will say, what are the big conflicts? And to quickly highlight them, we have an increase in the number of funded arbitrations. There's a small number of funders, like Omni Bridgeway that's on the line with Dana. The relationship between funders and the law firms actively involved in arbitration, it's a small cadre again. And then add in the fact that arbitrators are often selected by parties, repeat appointments, and the like. And how do we deal with all of this gray area and ambiguity? We need a clear, uniform, and perhaps binding regulatory framework if we're going to approach this notion of safety. And so to get to safety and security, we have started having conversations In 2014, the IBA's guideline on conflicts of interest. In 2016, the ICC guidance note on conflict and disclosure. The 2018 report on third-party funding that Catherine participated in. And of course, most recently, as of yesterday, GAR introduced to us Global TPF Alliance, Omni Bridgeway being one member of that 6-member cadre, trying to scope out and be proactive with self-regulation. How can we do it better? They spoke in that article about innovation and growth, and these are really important things in our new normal. But where we're looking for consistency and we're looking for safety, in truth, we are not there yet. With that, I will turn the floor back to Kabir.
Thank you very much, Rekha. The ding didn't work, but we had Ishan dancing, so very bravo for noticing that. So we have heard Rekha arguing in support of the motion. We're now going to move on to our second speaker, to our own Dana MacGrath, who will argue against the motion. Once again, just for everybody dialing in late, the motion that we have is this House believes that international commercial arbitration would be safer without third-party funding. Dana MacGrath arguing against the motion. Dana, the floor is yours.
Good morning, good afternoon, good evening to everyone joining us today, and many thanks to the organizers for including me in this program. And both Omni Bridgeway and ArbitralWomen are happy to support this program today. As previously mentioned, I am with Omni Bridgeway, which is a large third-party finance organization with 18 offices across the world. So you may know us in different parts of the world. I am based in the US in our New York office, but focus on international arbitration, both commercial and ISDS. Today, we are focusing on international commercial arbitration. Although as Rekha Rangachari mentioned, sometimes the issues overlap. I guess the key theme that Rekha focused on was safety or lack thereof, which is a concern that I think in many respects is, while thought-worthy, somewhat unfounded. I think to understand why third-party funding doesn't pose the risks that some people see it to pose, you need to go back to what is third-party funding and what does it do. And at its fundamental, arbitration funding makes it possible for companies, particularly small businesses and startups, but all companies, to assert commercial claims such as for breach of contract or other sorts of claims in private international commercial arbitration that they otherwise might not be able to assert due to limited capital. Funding is not only used by impecunious parties or startups, and many well-established companies choose to use third-party funding as a cash management tool so that their capital can be directed towards growing their business or launching a new line of their business instead of towards paying legal fees and costs. Funding allows companies to enforce their rights so they don't get taken advantage of by competitors in the marketplace or other bad actors. Funding is an important resource for companies that may face financial hardship due to economic downturn, which is the climate we live in today. While not impecunious or insolvent today, they may have challenges to stay solvent in the coming months. And sometimes in those circumstances, the choice by a company as to whether or not to assert a claim to enforce its rights is determined by whether it can obtain third-party funding to assert the claim. Now, it has been suggested, and Rekha mentioned this, that third-party funding may be a concern with respect to a basis for conflict of interest. I would submit that it is the rare arbitrator indeed that has a relationship with a third-party finance company. If an arbitrator has a relationship with any funder or with respect to some publicly listed companies and owns share in a litigation finance company, I would fully expect the arbitrator to disclose that fact. An arbitrator knows if it has a relationship with a funder and can disclose any funder relationships. That said, I understand that both ICSID and institutions that do more commercial international arbitration than treaty arbitration, while doing both, are introducing rules to address disclosure with respect to third-party funding. And that disclosure focuses on the very issue raised, the issue of conflicts, and calls for the disclosure of the fact of funding and the identity of the funder so that any concerns about conflicts can be allayed. And it is in everyone's interest, the parties, the arbitrators, and the funders, that any award resulting from an international commercial arbitration be enforceable. So I think we are all actually aligned in that, while it's presented in some respects as an issue in dispute. Finally, I would just mention that our arbitration funding, or any funding in the commercial space, really does not encourage frivolous arbitration. Established funders do not choose to invest in frivolous claims for obvious reasons. Arbitration funding is non-recourse. If the arbitration is not successful, the arbitration funder does not recover its investment and does not receive any return. Therefore, there is a strong disincentive for arbitration funders to invest or fund in cases that appear frivolous or weak. When a case is lost, not only does the funder receive no return on its investment, it may, depending on the contractual arrangement with a client, be obliged to pay the opposing side's legal fees. Therefore, I think the argument that arbitration funding fuels frivolous arbitration or litigation is unfounded. Mindful of time, and I missed the dancing, I'll cede the floor to the next speaker.
Fantastic. Thank you. Thank you, Dana. I did start dancing because the ding doesn't work, but I think the good thing we're having with our speakers here, and may I just share this with our audiences, that we have had these 4 speakers who have really prepared. And I think it just shows with how articulate and with how careful they are with time. So bravo to each of you. For folks joining in, the motion we have before this House is that this House believes that international commercial arbitration would be safer without third-party funding. Arguing for the motion, we have Professor Catherine Rogers. We've heard of Catherine Rogers' study that was done in third-party funding. Professor Rogers, the floor is yours. Professor, you're on mute. Forgive us.
Thank you. Sorry, let me start that again. Thank you for having me and for organizing this great debate. I'm going to pick up where Rekha left off with the concept of uncertainty and safety. I think that third-party funding is essentially inherently inconsistent with the entire concept of international arbitration, which is of course founded on the concept of consent. The idea of international arbitration is that before you enter into a contract with a party, you have agreed, because of privity you have with that party, that you are willing to pursue, if a dispute arises, a very particularized type of dispute resolution, arbitration, in which there is no appeal, there are no dispositive motions, in case there are, and I'll come to it in a moment, frivolous claims, and in fact, there is a reliance on the notion of confidentiality of the proceedings. The problem is that third-party funders are guests, are uninvited guests crashing the party. They have absolutely no privity with the opposing party, who most likely does not want them to be involved in the case. Now, the argument is, well, they're just sort of a neutral source of funds for one of the parties. And in that sense, they don't really add anything new or different. They don't have any conflicts. They sort of just provide an influx of funding. But in fact, that's not necessarily the case. It depends on your definition of third-party funders. And in fact, there have been a number of instances where third-party funders had a specific interest an independent interest in the substantive outcome of the case, not just a financial one. So for example, in the famous, and I apologize, it is an investment case, but I'll use it as an analogy, in the RSM case, which is famous for some of its more colorful discussion of third-party funders with regard to a request for security for costs brought by the respondent. One of the little-known facts about the case is that the funder in the case for the claimant was perhaps the less interesting of the two. What was really interesting is that the respondent was also funded by an oil and gas company that would benefit if the claimant lost the case. In addition, and we might be a little bit more sympathetic, but in the Philip Morris versus Uruguay case, in fact, the respondent there was also funded by an external entity that had an interest in the substantive outcome of the case. So this idea that it's just a neutral source of funding, I think, is not accurate, and it goes back to the uncertainty question that Rekha raised in her opening remarks. In addition, I'd like to take up the question of frivolous claims. Now, I'm very familiar with this argument, and in fact, I would always have confidence that Omni Bridgeway and Dana would never bring a frivolous claim. But the problem is that not all funders have the same status and experience. In fact, there's absolutely no criteria for being a third-party funder. Anyone can be a third-party funder. And that means that, for example, any entity that has money could decide that this is a really great way to, instead of going to Las Vegas, to gamble on some very high stakes cases. And they may not necessarily have the same incentives, the same processes for selecting out responsible, respectful cases. And once again, going back to the peculiarities of arbitration, if they do bring frivolous cases, there are no dispositive motions, there is no appeal. So the meddling of an uninvited third-party funder could wreak real havoc. And the reality with frivolous cases, as again, notwithstanding assertions by responsible third-party funders that they would never do it, we can never know. Why? Because we don't know if cases that were brought and were resolved through arbitration are frivolous. Why? Because they're all confidential. In litigation contexts, there's a constant monitoring of the effect of such things as insurance and third-party funding, and they can respond with regulation. There's an attempt to respond with regulation right now in international arbitration, but it's been largely ineffective and ignored. Finally, I will conclude with what I think is one of the other concerns, which is some people say, well, third-party funding can be very useful because it facilitates access to justice that might otherwise be unavailable. The problem with third-party funding in international arbitration is it does no such thing. The claimants that need the money the most or that need funding the most to be able to bring their claims are smaller, medium-sized entities for whom arbitration is prohibitively expensive. But funders' model for funding generally can't accommodate these kinds of claims because in arbitration, the ambiguities in terms of deciding which cases are appropriate or not. Is that the buzzer? Have I done? In conclusion, I want to say
you have 30 seconds more.
I was told that I had to argue this position, so do not take anything I said as my literal viewpoint. Kabir promised he was going to say that before I started speaking, but I wanted to make sure I said that myself at the end. Thank you.
Awesome. So I will repeat, every speaker here speaking in their individual capacity. We don't want in a brief 20 years from now, someone saying, Professor Roger said funders are uninvited guests. Everybody's speaking in their individual capacity. Once again, for folks who are signing in, the motion before this House believes that international commercial arbitration would be safer without third-party funding. As you have seen, our speakers so far, all human clones, because that's the only way they can accomplish what they have done. A final, last but not the least, Professor Crina Baltag arguing against the motion. Professor, academic, arbitrator, counsel, she has done it all. Professor Baltag, the floor is yours.
Thank you very much for the introduction. I'm already biased, double-hatted, so I'll continue the position advocated by Dana with many thanks for the invitation. I do believe that we are trying to throw the baby out with the bathwater, and we don't want to do this. I would like to say that third-party funding is here to stay, and from all that was submitted before, I could hear that inconsistencies are present, and until it is consistent, it is not safer. So there is an admission that we're at the beginning of something that is here to stay. And as with any innovation, like all human beings, going back to the babies, they are not perfect when they're born. They learn how to walk, talk, eat, perhaps too much, but they become well behaved with time. So this is where we are, and I think that we all submitted that there were excellent advances up to this point at many levels, and I'll get back to this immediately. So what we have here, I think it's a bit of a confusion whether we are talking about third-party funding as a matter of principle, without going into the definition of third-party funding, or we're debating whether third-party funding, as Professor Rogers put, is inherently incompatible with the arbitration proceedings, and therefore we look at the arbitration proceedings. And I can hear a lot in the perception against third-party funding that is a sense of disagreement with the third-party funding in itself, perhaps because disputes, in essence, should not be considered as investment vehicles. You should not invest in a dispute. But I guess we're all learned practitioners at the table, and we're probably not discussing this. In turn, one should debate, and not based on perception, whether third-party funding can actually compromise or alter the arbitration process to that extent to make it unsafe for arbitration. And there are some points made during this debate. One was with reference that third-party funders are not parties. I dare to say that amicus curiae in the arbitration proceedings are not parties, but they are still admitted to the table. And we've seen in their case the evolution or the slow evolution of the regulations, the treaties in investment treaties of allowing and putting boundaries to the participation of amicus curiae. We've also heard about funders funding cases just to obtain more favorable awards. And the examples given by Professor Rogers, of course, they're not singular. There are other cases like Quasar de Valores with this exact same situation where the funder invested just to get a more favorable award to be used in the subsequent arbitration. But hey, this is also used by the arbitrators in the double hatting. This is not specific to third-party funders. So the question is, can we make third-party funder safe for arbitration? And the answer is yes, and it is safe, and it is starting to be safe for arbitration. But for this, we have to look at the arbitration in detail. We have to look at the third-party funders and the third-party funding as an industry and start regulating it. And we've heard that this is done self-regulation, but also regulation by national laws and arbitration rules. And we have to look also in parts at the relation between third-party funders and the parties, the funded parties, third-party funders and the lawyers, third-party funders and the arbitration process, duration and costs, third-party funders and the arbitral tribunal or the opposing party. And of what I've heard, they all have a solution at the table. It is just a matter of allowing some time for this baby to grow and for innovation to become familiar to us, and therefore to allow third-party funding to be here to stay. How Dana put it very explicitly was that third-party funding is here to level the playing field, and I think that's an important thing to put forward, and of course to promote access to justice. Thank you very much.
Bravo to each of our speakers. I invite everybody to give a clap to our speakers for their excellent presentation. What I particularly enjoy, and I will invite all our participants to do this on YouTube, pick up your favorite quote from each of our speakers and put them below, because there have been such beautiful sentences from each of our speakers. So bravo for your thoughtful talks. Bravo also for the creativity that each of you brought in. We're now going to move on to phase 2 of our debate, the question and answer session of the debate. And let me pass the floor to Ishan. Ishan will ask the first question. We're now going to have our speakers engage with one another. We'll try to see if there is some convergence. We'll try to see areas of divergence. We'll try to see issues a little more granularly. We're going to look at your questions that you're putting in, combine them and present. Ishan, the floor is yours.
Thank you so much, Kabir. And thank you so much to the speakers for such wonderful presentations. I still can't decide. Even if I have to be biased, I am unable to do that because I still can't tilt either way because of the opening statements that you made. And thank you so much for that. But then now, let's open it wider. Let's talk about some core issues that you've already touched upon. And one of the major questions and doubts that arise as regards third-party funding is about the source of money. It has been argued that third-party funding in international commercial arbitration can give rise to potential arbitrator conflict issues, while others have argued that there is no possibility of conflicts either because of the nature of funding or if funders' participation is not disclosed. Can the participation of funders raise conflicts of interest for arbitrators that we should potentially be concerned about? I mean, what does it matter where the money comes from? I could get it from a friend, I could get it from a bank, I could get it from any other kind of financer. It could be insurance, it could be contingency fees. So how does it matter where the money comes from? And what's the deal about conflicts? So I invite the team for the motion to talk about it, please.
You'll have to excuse us. We didn't fully coordinate this, but I'll kick it off and then pass the torch to Catherine. You know, conflicts has been something that we have raised as a major issue. Why is it an issue? Because this larger fear of set aside of an award. You know, Dana has suggested that there are very few awards that we know of that have been set aside. But in truth, how many of the awards do we really know of that are in the public domain and that have gone forward? The problem really becomes, right, this notion of perception, because conflict and disclosure is a subjective one as defined in many of the arbitral rules. And so where it rises to a level where there may be a connection, how do you always know? How do you unearth it? While it's great where an arbitrator would know and readily discloses, what happens in the instance where it doesn't, and how does it then upseat everything that has happened and all of the costs involved in the proceedings there too? With that, I'll pass the torch to Catherine.
Or we can, I'm happy to let Dana or Crina respond. Otherwise, I'll jump in and give you more to respond to. Do you want to respond now or later? I'll go ahead. Okay. So a couple of things. One, I think I would say, I think it's fair to say that I have never seen an award that's been set aside based on a conflict of interest with a third-party funder. So that's the good news. It hasn't happened yet. But I also think it's an overstatement to say that this is not possible somehow because we trust third-party funders to have survivalist instincts. So they would never fund a case where there'd be a conflict of interest, because in fact there has been such a case that became public. It was not challenged because the arbitrator the case ended up being consolidated with another case, and therefore the very blatant conflict of interest, which I do believe would have been grounds for a set aside, ended up essentially going away because of the consolidation. The arbitrator did not stay on the tribunal and actually eventually passed away. But the fact that that even happened suggests that A, it's possible that a third-party funder may end up appointing an arbitrator with whom they have a conflict of interest. And I think it's also possible, as in that case, where the arbitrator doesn't necessarily know. And particularly, I mean, just to deconstruct this for a moment, how can the arbitrator know about repeat appointments? The only entity that knows, for example, that the third-party funder has on 7 different occasions, hypothetically, in the past 2 years, appointed the same arbitrator because they like the same outcome, is the funder. Even the parties don't know. So the claimant can't make the disclosure. The arbitrator may or may not know, particularly if there was no disclosure, they wouldn't necessarily know. And so the only entity that can know, that knows about consistent repeat appointments is the third-party funder. Now, there's an argument that's been made that says, well, if the arbitrator doesn't know about the conflict, then they can't be biased, and that's not a problem. Well, first of all, of course, it can come out later, as in the case that I just mentioned, where it did come out later and was, I think, according to reports, part of the reason for the consolidation, number one. Number two, arbitration has a binding effect that raises the stakes of these kinds of conflicts. So the idea that you could, and it's a disaster for everyone, including the third-party funder, if this conflict of interest essentially gets embedded in the case and is only discovered later. So the idea that if the monkey, the see no evil, hear no evil, speak no evil, that just doesn't work. And that's not how we run arbitrator conflicts of interest and arbitrator disclosure rules. We have rules that say we require broad disclosure that allows the arbitrator to make an informed, responsible decision about whether they have to either disclose or recuse themselves. But in this context, where there are, apart from some national mandatory rules, there are no binding rules that require third-party funders to make disclosures. My understanding, at least from some third-party funders' public statements, including established third-party funders, is that to the extent that those rules, so-called rules, are only guidelines and are not legally binding on them, they don't have any intention of disclosing when they don't have to. And that creates a problem, because then I think also you have some funders who might be disclosing in an abundance of caution, others who are not. So again, the question in the debate is, would international arbitration be safer without third-party funding? I think without disclosure, systematic required disclosure, that is also observed by the third-party funders, we do live in a zone of unsafety. And I'll close with this point, which is, it's one thing if there's misconduct in the courts. There are lots of different remedies you can invoke to kind of cure that, to fix that. You might be able to, the court has an inherent power to do that. Arbitral tribunals have no power over third-party funders. So if they misbehave, in a sense, there is no recourse. Moreover, it's the parties and this community that suffers. If third-party funding becomes a black eye for international arbitration and undermines the sense of legitimacy and confidence that we have in the system, it will be incredibly difficult to earn that back. So I think, as Rekha said, there is a perception problem. I think Crina also said, and for these reasons, I think I'll go away from the actual question and debate to say, we could have third-party funding, or we can be confident that it would be safe. But I do think that conflicts of interest with arbitrators are really what have raised these questions, what have caught the attention of regulators in the first place, and they're the most important issues to ensure that participation of third-party funding in international arbitration is safe.
Thank you so much, Professor Rogers. Towards the end, I do see that you do agree that third-party funding does have a future. But then let's talk about third-party funding from the perspective of a third-party funder. And I think for the purpose of this debate and audience, the disclaimer still applies. I invite Dana MacGrath to please respond to Professor Rogers' comments here.
Thank you, Sean. And thank you, Catherine and Rekha, for your comments. I mean, I think these are all important issues to discuss. And so while I am against the motion, I think that you have raised some important issues. And I'd like to sort of maybe change the framework a bit. A lot of the discussion that I heard was, third-party funders are appointing arbitrators. And in my personal view, which is informed by my professional experience, it is not third-party funders who appoint arbitrators. Parties and counsel control the case. Third-party funders provide capital such that the lawyers can be paid and or the arbitration costs can be paid. But it is not the third-party funder who is appointing the arbitrator or arbitrators. That said, I don't claim that eliminates the issue of potential conflicts, but I think it's really important not to see this as third-party funders, at the party, a seat at the table. They are non-parties to the arbitration. They have no control over the arbitration. I've noticed that some people have raised questions about the element of control and the degree of control that third-party funders have. In my view and experience, third-party funders do not make the decisions. The parties and their counsel make the decisions on all aspects of the case. And importantly, to this issue with respect to disclosure of funding, I think it is a discussion that should be had between the counsel and the client and the funder in every single case. What do the rules apply? What does the national legislation apply? What does the party want to do? What does counsel want to do? You know, we as funders obviously want to protect the enforceability of the award, and if disclosure is part of that and required by the law or implied by a myriad of overlapping non-binding guidance and notes, and you know, there's a whole sort of matrix and maze you have to swim through for some institutions or arbitrations, you know, to sort of figure out where to come out on that. If the client and the counsel want to disclose, it's usually disclosed up front. Often in arbitrations in Asia, where it's required in either the rules or the legislation, it's disclosed as early as the pleading. But also, third-party funders don't always enter at the pleading stage or the pre-pleading stage. So, you know, they might come in midstream, and so then it's disclosed midstream. I'd noted that the TAC rules, you know, there's TAC rules that apply to international commercial arbitration, and then there's different CAC rules that apply to investment arbitration, and the disclosure requirements differ. So it's in ISDS, the last debate, where we would have discussed the rule with respect to disclosure of the funding agreement. In the commercial context, it's disclosure of the fact of funding and the funder. And I think this is a difficult issue because institutions are still developing their guidance on these issues. So it really turns on the reading sometimes of the counsel and client of the rules and guidance of a particular institution. So I think we're going to hear more on guidance, if not regulation, on disclosure of third-party funding. But fundamentally, international commercial arbitration is private arbitration. And party autonomy and private arbitration should not have a presumption that third-party funding should be disclosed. The presumption should be that it's private arbitration and decisions are made by the client and counsel. And the funders do not control that. I'll let Crina add to that if you would like to, or take it in a new direction.
Thank you, Dana. And yes, I do invite Dr. Crina to talk about it, to respond to what Dana said, and specifically about the consequences of non-disclosures and why disclosure is important.
I do appreciate all the arguments put forward, and I think it is important, and we're all on the same page, that we do need regulation on this aspect. And we have to appreciate also the fact that the IBA guidelines, they started to tackle the issue in a more comprehensive way at an early stage. And I think the ICA report deals in great detail with the situation. In the sense, the question is, what happens if there is no disclosure? And it's not only about the non-disclosure of the funding itself, but we have situations, and we could see in ISDS cases, a non-disclosure when it was of the funding agreement. And perhaps we'll get to a later stage of the implications of third-party funders in the process itself as party or beneficiaries. But the question is, what is the sanction? What if there's no disclosure? And we could hear that we'll see this at the later stage, probably when it will be too late in the post-arbitration. But there are solutions for this, and one could turn their eyes to the ISDS again and to the investment treaties, because there has been some specific provision included in recent investment treaties, such as Indonesia-Australia Comprehensive Economic Partnership, where the non-disclosure of the funding or the funding agreement could allow the tribunal to suspend or to terminate the proceedings. I'm not saying this, obviously, because I'm not supporting this, but what I'm saying is that there is a solution for everything. If we look at the IBA guidelines, we can see that the interest, or at least it is considered that the economic interest of the third-party funder in the case might makes the third-party funder to be considered as a party for the purpose of the IBA guidelines. And therefore, it's easy for one to make their way through the red, orange, and green list and understand exactly where the situation is. So we do believe that the disclosure is important. We also believe that institutions, stakeholders in general, and parties, they do have, as Dana said, they do have this in their hands, and it can be provided expressly, and specific effects could be given during the arbitration proceedings and not necessary to wait for the arbitration proceedings to be over. Thank you.
Fantastic. Thank you. Thank you to each of our speakers. You know, this is a beautiful thing when you have very smart people talking, because we're able to look at an issue and look at it with nuance. We're going to move on to our second question. And Ishan and I have decided to improvise. So with many apologies to our speakers, we would like to present our next question, but we'd like to give our speakers just about 1 to 2 sentences to respond. We're doing this partially for time so we can get through more questions. So we hope this is possible. So let's do it in a rapid fire style. Make your answers fiery. Now we're combining a lot of questions that are coming together and trying to present it. And the question seems to relate to relationships between funders and law firms, right? That's the broad rubric. And the question is something of this nature. You know, we see some funding arrangements that directly implicate law firms, right? If you have a success fee, if you have a contingency fees, there is this direct relationship. But now recently, we're seeing that funders are engaging in portfolio funding. This is something where we're seeing a lot of comments. There's also a direct interest, a direct investment in law firms. There is ownership of law firms. So the role of funders has really expanded in some senses, right? Now, do these arrangements, these latter arrangements in particular, raise issues for lawyers and law firms? And we're just going to add another wrinkle. You know, ethical standards vary across the world, right? There's no uniform ethical standard. What implications do these new funding arrangements have in a global setup where you have diverse ethical standards? I know this is a very meaty question. It is a compound question with various levels. And we are obviously giving our speakers 1 to 2 sentences. So I recognize the unfairness in what is happening here. Perhaps just to change the order of speakers, we now have the team arguing against the motion to make the first statement for a sentence or 2, then the team for, then the team against, and then the team for. So Professor Baltag, Dana, would either of you like to start with this, and then we'll pass it on to Catherine and to Rekha?
I'm happy to start with a disclaimer that 1 to 2 sentences for a lawyer, even a recovered lawyer, now funder, is a high bar to meet, especially given the long introduction to the question. That said, I don't believe that portfolio funding or the various new structures that are being implemented make the conflict issues more severe or of concern. Portfolio funding is something that's pretty widespread now in the funding space. It actually diversifies the risk and the connection by the funder to each case individually. So in that respect, it actually makes the conflict issue, if there is one, even more attenuated. I'll stop per the rules, but I could go on.
We are very grateful. I recognize what we're doing is mafioso, but we appreciate this. Just in the interest of time, perhaps we have somebody for the motion either respond to what Dana said or make another key observation that can add to our debate. Professor Rogers, Rekha, anyone if you want to go first?
Unless Rekha wants to jump in, I'll go ahead. That doesn't count as my first sentence. I would say I agree with Dana that the point of portfolio funding is to diversify the risk, but that's exactly the problem with it. When you detach the risk of loss from the investment, you increase the potential for third-party funders to fund through diversified risk portfolio, frivolous cases in the portfolio. That's my 2 sentences.
Thank you very much. My favorite t-shirt, unmute yourself. Thank you, Professor Rogers. Very grateful for that. Professor Baltag, do you want to respond?
I do, and I do not want to pick up on what Professor Roger has just mentioned, but I do want to pick up on something that Dana put forward, and that is where the legal profession is heading to, and that's alternative schemes or alternative types of organization of law firms. And we see, for instance, in England and Wales, we have the alternative business structures. Of course, this is part of the big picture, that is where we're heading towards. The legal profession is diversifying, and so third-party funding.
Thank you. Last but not least, Rekha, words of wisdom to close this question.
So as we keep diversifying, we're also getting new schematics and sharing of risk. And the problem, it goes back to the inconsistencies in the landscape, whether we look at contingency fee cases or otherwise, prohibited in some jurisdictions and not in others. How do we get to sort of a global recourse on what are the best standard and what is the best path forward? These modulations, while intriguing, make it difficult, I think, to make that overall stance and help us with best practices.
Thank you, and bravo to each of our speakers. Each of you did it in 2 sentences, and we thank you. And that allows us to have the last question. Let me pass the floor back to Ishan to ask the last question.
Oh, thank you so much. Thank you so much. In fact, I'm just keeping a track of the time, and suddenly with this previous round of question number 2, we are back on track that we can actually cover not just the one that I'm about to ask, but also another question. So I think if we follow the same rule of 2 sentences, or maybe stretch it to 3, I think we can cover all the questions and also definitely gain a lot from your wisdom on this. And moving on to the 3rd question that we have today, and it's something that Professor Rogers already slightly touched upon, but I think it's important to ask this question straight up and also have answers that are straight up. Again, disclaimer applies everyone. Now, in investment arbitration specifically, we hear a lot about arbitral hit and runs. Things are more transparent, or at least more reported there, so therefore we can get to hear about those issues. But when it comes about commercial arbitration, there is more secrecy, more confidentiality, and a lot of things do not come to the limelight and therefore under the carpet or in the air. So the question is, can or do funders increase the possibility that unsubstantiated or even frivolous claims may be brought, given the high cost of arbitration and again, the limitations on systemic assessment because of confidentiality and secrecy? Is this a more serious concern than funding of litigation? And I will ask the team 4 to please move first. Professor Rogers?
Yes, that's my first sentence. In investment arbitration, there are states who firmly believe that, in fact, the presence of funders has increased frivolous claims, and they wrote a letter. The government of Panama wrote a letter to ICSID to that extent. We can't know in commercial arbitration because not only is it secret, but there isn't this collaborative alliance among responding parties so that they can essentially share notes informally even. And that added deal of secrecy, I think, raises the concern that we cannot know if third-party funders are in fact raising frivolous claims. And I'll add a footnote to my 2.5 sentences, which is, again, the problem is not Omni, Bridgeway, or the established responsible funders. The problem is that anyone can fund, and we don't know who is funding or for what purpose. And there are no minimum requirements to be a funder, except that you have money.
Dana, please.
Okay, and I appreciate that you did not throw Omni Bridgeway in the category of a funder who would fund a frivolous claim, as we do not do that. But I appreciate that the landscape of funders is wide, and there is a lot of different forms of funding, and so I hear that issue. I think that in the end, it is still really unattractive to invest in a claim that looks like it has really marginal merit, because the money is non-recourse, or the investment, whatever form it takes, is non-recourse. And I also mentioned that, Rekha raised some good points about how funders are not the only ones who are putting money at risk in the context of a commercial arbitration or a dispute. Lawyers on contingency arrangements and the like also have similar investment, so to speak, you could say, and that is increasingly permitted around the world, as is third-party funding. So I think that we're moving towards more uniformity in terms of what's permitted, and with more uniformity of what's permitted, I think we'll see more uniformity of how it's done, and more knowledge sharing about what structures and ways it's done.
Thank you, Dana. And Rekha, please, your 2 cents.
The issue I think here goes back to also this notion of self-regulation. And again, not to underscore it enough, there are rogue funders out there who could indeed ratchet up frivolous claims, and we just don't know enough about it. The unknown is exactly what pushes against safety, our major motion in today's debate.
Yes, fear of the unknown, definitely. Dr. Crina.
I would go back to what Professor Rogers mentioned before, in the previous question, whether the portfolio funding is the actual problem that would allow frivolous claims. Because what we could hear from Dana and what we know, and that's not perception, that's the reality, funders do pick up their funded disputes extremely carefully. And you have to think about this not only because lawyers will have the skin in the game, but also because at the initial stage of getting the funding, there is a lot of effort invested in the case, and no one, I don't think, would go that way unless it believes in the dispute.
Sorry, I'll just jump in. And I want to go back, slightly disturb the format for this particular round, but I want to go back to Dana and ask about this new framework that came about last week, the International Legal Finance Association. And that's something that might help quell the fears around third-party funding. Can you please tell about that?
Unmute, that doesn't count as my 1 sentence. So the International Legal Finance Association is a very new development in the field of third-party funding. And it's an organization that was founded to represent the global commercial legal finance community, which has been sorely needed, I think. And this is a great development. And it will serve as a global voice of commercial legal finance. And it's very new, so there's a limited amount I can tell you about it, but it is the only global association of commercial legal finance companies, and it's an independent nonprofit association. And it provides high standards of operation and service in the commercial legal finance sector. I think it is in part fueled by the concerns of uneven levels of regulation, ethical standards, and what is appropriate conduct for funders across the globe.
And so a handful of funders came together to launch this organization. So in furtherance of its mission, the members, for now, are the founding 6, undertake to comply with best practice principles. And I think that just sort of echoes some of the things that have been mentioned earlier, that some of the established funders who have been in this space for many years, in our case, decades, recognize that we are in this for the long haul. This is what we do as our business. This isn't dabbling in funding across doing a lot of other financial transactions. What we do is funding disputes. And because of that, we're very interested in protecting the industry, its high ethics, its respect, transparency, allowing people to understand what funders do and what they don't do, and how they don't control the litigation. They don't control the arbitration. I think a question was asked about settlement in one of the Q&A. I can't follow it so easily while participating, but funders do not control settlement. Funders fund, and they make their decision as to what to fund based on their extensive due diligence. I can only speak for myself that that's diligence that I myself perform with my team. It's not something that I outsource, and at the same time, I'm very mindful, and we are all very mindful, I think, in the industry, at least the major funders in the industry, to approach it ethically, and in fact, even empower lawyers to understand better the ethics that are and best practices that apply to funding. So I think it's early days for what's called the ILFA, the International Legal Finance Association, but I think it's a fantastic development because it demonstrates that the established funders in this space globally want to even the playing field, distribute information and knowledge, empower all stakeholders in litigation and arbitration where funding takes place to understand more about the industry of funding and the limits, the ethics, and how it's approached. So hopefully it will be a fantastic resource for clients and for law firms and for all stakeholders in dispute resolution around the world.
Thank you, Dana. And I see we only have 15 minutes for the event left, so I'll quickly request Kabir to somehow club the last question and the closing arguments together.
Fantastic. And let me just, this is a privilege to have such fantastic speakers that we're getting questions on the chat, on the Q&A. We're getting a lot of love and keep sending them in. Cognizant of the fact that we have superstars here who have jobs, and for Professor Baltag, actually, it's the end of a day, so we really appreciate, folks coming in early and late. So not to push our luck here, let's move on to our closing arguments. And we will request each of our speakers to make closing arguments for 2 to 3 minutes. Again, we'll follow the 4 against, hopefully in the same order, but if our speakers want to change it, that's totally fine. As Ishan mentioned, we had a 4th question. That is a good meaty question. Now, rather than pushing our luck by going way beyond time, I'll just present the question. And if our speakers would like to address that in their closing statements, feel free to do so. The question is, wait for it, da-da-da. This is really getting to the meat of what our speakers have teased out so eloquently, Third-party funding is subject to different regulations, right? And you find these regulations in a variety of sources. It's sometimes national law. It's sometimes bar rules. It's sometimes rules by arbitral institutions, or it is soft law. So you have this wide array that intersects at different levels. And this is the question, is this, bifurcated, trifurcated approach a healthy way to vet the relevant issues, or does it cause uncertainty and confusion? That is the question. As our speakers make their closing statements, you may wish to engage with this. With that, let me ask the team arguing in support of the motion. Rekha, would you like to start? Rekha, you're on mute, my favorite t-shirt.
Thank you. Well, in brief, I think today, again, the question posed was about safety, and uncertainties are really driving erosion of safety in the process. We are at a state where there's a lot of progress and a lot of innovation, including the group that Dana highlighted that Omni Bridgeway is a part of. But the truth is that the exception can swallow the rule if rogue investors in some way get involved. Self-regulation is inconsistent. Disclosure maintains inconsistent. Party autonomy can sway into a gray area, perhaps with settlement agreements, and conceivably influence orchestrated therewith by a third-party funder. And then, of course, inconsistencies as to the right to recover against global jurisdictions, whether it's a contingent fee structure, or a portfolio fee arrangement. And so the truth is that all of these inconsistencies can erode a process. In truth, third-party funding is not going away. If anything, it's become more robust. And so to that end, we are at a pause state where we need to figure out what are those best standards. Not only what is the soft law, but what more can we do? So there's a there in this overall process. Thank you.
Thank you, Rekha. There. With that, let me pass it to Dana. Dana, would you like to make your closing statement against the motion?
Yes, I would. I stand firmly against the motion after this long discussion. I think important points have been raised, but in the end, the motion should be opposed. With respect to the myriad of regulation or soft law or guidance notes, and what I've heard today, the suggestion of more uniform regulation or something like that, I would urge that any such initiatives include funders and participants in the funding industry in that discussion. And I think part of what has caused the confusion and some of the red herrings that the funding industry is trying to respond to, like whack-a-mole, is that some of the guidance that has been put out with respect to third-party funding has been done with no consultation with people who actually do third-party funding. And if we can all unite and have, a true discussion amongst all stakeholders, we'll probably have a much more clear and productive and fair and safe result with respect to, if you want to call it regulation, best practices, ethics, whatever you want to call it. If we have a discussion with all the stakeholders, I think the result will be much better. Thank you.
Thank you very much, Dana. For our audience, the motion is, this House believes that international commercial arbitration would be safer without third-party funding. As you know, our speakers are speaking in their individual capacity. We have closing arguments. We're going to have Professor Rogers now make her closing statements in support of the motion. Professor Rogers.
Thank you. I think I will make my closing argument in support, and then I will say a few words in my own voice. In support of the motion, there's an ancient proverb that says, "The enemy of my enemy is my friend." And I want to start with that because we all assume, perhaps at least in this discussion, because we have Dana here, again, this identity of third-party funders, that they are these responsible, respectable, established institutions that have the knowledge to be able to pick carefully cases they believe they'll win. They have established experience in writing contracts that are fair, that leave the control in the parties' hands, including, we saw a question about settlement. They have a fair way of dealing with that. They have NDAs to protect confidentiality. The problem is that you don't necessarily know that the funder that comes in would not be some independent established third-party funder, but at least can be it's at least possible that it could actually just be a business rival who thinks that they would benefit by funding your opponent in some litigation or arbitration. And I say that because in fact it has happened on occasions, and because Oliver Wendell Holmes said, and I think this goes back to the point of regulation, that regulation is written for the bad man. We don't write regulations for the people we think are already behaving in a way that's proper and appropriate. We write regulations to protect against the worst case scenario when you have a bad person come in who wants to take advantage of the absence of regulation, wants to take advantage of the fact that everyone has agreed to just play nicely according to non-binding norms that we politely call best practices and we all informally agree to abide by. Regulations are written for the people who will say, I don't care about those. And I think the stakes are too high in international arbitration to allow that to go forward. That's my in character defense in favor of the motion. I would like to say just at the end, I do think that Dana made an excellent point that as a community, it's really important to have all the stakeholders at the table. And I'll just say here in conclusion a few words about the ICA Queen Mary Task Force on Third-Party Funding, which in fact did exactly that. We invited some of the most prominent and I would say responsible and thoughtful funders to participate in that task force. A number of others participated sort of ad hoc and gave comments that were really helpful to us. And in fact, I will say also, I think our report was almost outdated while it was printed, because it is such a fast-moving area. I agree with Rekha that this is not going, and I think Crina said the same, Dana, that her career on it, third-party funding in international arbitration is not going to go away. They are not necessarily unwanted guests anymore, but they are our guests. And I do think that for many years we worked hard to establish clarity in the rules and in the boundaries of what parties can and cannot do. Many of those are binding on the parties legally. And I do think we're going to have to figure out how to make sure that everyone understands what the boundaries are appropriately and inappropriately for third-party funders. And of course, third-party funders have to be part of that conversation. You literally cannot understand, how it works without inviting them to the table. So with that, thank you for having me at the debate. And I would like to underscore once again, we were promised there would be a scrolling reminder that we were acting a part in our arguments for and against. I argued some things I believe and some that I would not necessarily say, except for having been assigned the role. Thank you.
Thank you very much, Professor Rogers. The video will indeed have the scrolling for folks who are watching it on YouTube. You see it. Our speakers are speaking in individual capacities. Last but not least, our own Professor Baltag. The floor is yours to end the debate.
Thank you very much. And it's very difficult to be the last one speaking after absolutely impressive concluding remarks. I would go back and state the obvious that since we're here with the third-party funders and third-party funding, our mission is to make sure that the approach of this, let's say, regulation, one would call it reform, would be to have an inclusive, as it was mentioned, but also a unified or uniform regulation. But I do believe that this approach has to be taken on different aspects of third-party funding. There has to be an approach that concerns the industry as such, third-party funding and third-party funders, as well as the relation between the funders and attorneys. And I'm sure that we all think about issues, or we've mentioned issues of confidentiality and privilege, and between third-party funders and funded parties. And we all know how important it is that any party that is funded would get independent advice when it comes to signing the third-party agreement. So on this side, I do suggest that the regulation approaches aspects as much as possible in a unified manner. For arbitration proceedings, again, this has to be viewed from the perspective of the arbitration proceedings, opposing counsel, and arbitral tribunal in interaction with the third-party funding. And with this, I do want to keep the baby here, so please do so. Thank you.
The baby is here to stay, to quote Professor Baltag. Let me just invite all our speakers, all our audiences to give our fabulous speaker a clap, a virtual clap. It's really, really been an honor. I personally feel I knew this was going to happen, but it's always lovely when you hear speakers and you feel you have come out learning something. So thank you so much. It is not going to be fair to have a judgment with having such fabulous speakers. That's not the point of this debate. So we're not going to be doing a judgment on YouTube. We invite all our participants to put in interesting points they have learned. I think that is going to be a rich way to acknowledge the fantastic thoughts we've had from our speakers today. Let me turn the floor to Ishan and then to Chris to make the final remarks. Just once more, brava to all our speakers.
Thank you so much. I completely second and echo Dr. Kabir's thoughts that this was a great debate. B, it didn't seem like a debate in the sense it was more constructive and it was a very good free-flowing dialogue, which actually brought about a great deal of thought that, again, a lot of our listeners we can actually see from the comments and the chat, are appreciating, because there's a great deal to learn from this. Of course, it will be unfair to rule on the motion which way, but definitely I think one thing that can be said, that it would be safer to have third-party funders in a way that we have them with the understanding that they share what is going to happen, how they function, with a bit of regulation, with a bit of transparency, as some may say. But definitely, there's a lot that has to be developed in this field. And as Professor Rogers said, that the report was outdated even when it was finally published, and it's a very fast-moving field. And how it pans out in the next 2 years in the post-pandemic scenario will tell a great deal about how the field evolves and how these issues that we discussed in the form of questions are going to pan out. And of course, there's a lot that's going to happen there. Again, at the end, I have to announce the disclaimer again that all the views shared here were solely for the purpose of the debate, and no one particular view can be attributed to any of the speakers. Once you revisit and watch this recording on YouTube, you'll definitely find that scroll going all across announcing that disclaimer. And we are grateful for all our speakers to share their views, which may be different from the organizational views, and sharing them for the purpose of the debate and acting as the devil's advocate wherever required. And thank you so much to our audience. And now I invite Chris to please share his screen time with us and share the closing remarks, please.
Thank you, Ishan. Thank you, Kabir. Rekha, Catherine, Crina, Dana, it was fantastic. I think third-party funding and a safe arbitral process are in good hands if we leave it to people like you to come up with sensible regulation, really. Fantastic contributions by all of you. And I'm looking forward to the next ArbitralWomen webinar. Thank you very much to the audience. Have a great afternoon, evening, wherever you are. And until the next time.
Thank you.
Ishan, when is the next time?
It will be pretty soon. It will be announced all over social media.
Okay. Thank you, everyone. Thank you very much. Thank you.
Everybody, have a lovely day. Bye.
Bye.
So, that was good, Ishan.
That was great, must I say, as always, because of our panelists, because of us.
Yeah, I know you've had great panelists, and again, great panelists. And yeah, no, it was a very well managed, both by the moderators, but also by the panelists themselves. Just keeping their remarks very pointed, and I would again say that's probably an advantage of involving arbitral women, because I also find that women are much better in doing that. Yes. Than men are. We tend to rattle on like I am now. So.
Well, they manage better anyway, always. I know it was
very
great
good
to have ArbitralWomen and Dana talk about ArbitralWomen, because there's going to be a fresh generation of lawyers from many developing countries who are going to get into the field. And the problem with most developing countries is actually women getting the opportunities in an equal proportion. And getting affiliated with organizations like ArbitralWomen is going to go a long way. So yes, and
yeah, it's you know, I mean, I think you know, that the panelists you had here are, you know, besides being women, they're all, I'll say, relatively young. You know, they're not, you know, the 50 or 60-year-old generation. So they're also, you know, going to be available in the future to move things forward and stuff. So really, it's excellent, definitely. Okay, I will be in touch, and you'll be in touch. Congratulations on another fantastic webinar.
thank you for being a partner in that.
Thanks for letting me. I mean, I'm not, you know, as I said, I'm not really doing anything, and I'm very happy just to be an attendee and stuff. But it's nice of you to, you know, give me the chance to open it at least and stuff like
Great.
that.
Yes,
So.
this series, CILS ArbitralWomen post-pandemic series, is going to continue with greater events every time.
Oh, I just hope someday the pandemic will be over.
Yeah. Well,
you know, we can't maintain this pandemic forever just so you can have these events.
It will still be post-pandemic anyway.
Well, yeah, that's true. Let's hope. Maybe it will never be post-pandemic.
Yeah.
We'll find out that it's been inappropriate for us to have these events before the pandemic is over.
Right.
Okay, you take care, Ishan. I'm gonna check out now, and we'll be in touch.
See you.
Thanks a lot. Bye-bye.
Bye. Bye.